I could argue that even today, at the height of tremendous success, that you do not function in the larger society, you function in the African American world, that you're head of this predominantly African American organization that came out of this predominantly other African American organization that devotes most of its energies to righting wrongs committed against African Americans, that you're an African American leader.
Well, I am an African American, and you're right that I lead an organization that is looking after the interests, trying to protect the interests of African Americans, but also something else. I cannot do it by myself without other communities in this country buying into that notion. White America, Latino America, Asian America. At LDF, our cases not only impact on African Americans, they help white Americans. I can give you example after example. White Americans, Latinos, Asians, because it's the law. And once you change an impact on the law, it impacts on all of us. Okay.
Of course, it keeps coming loose.
I need another piece of tape. It impacts on all of us.
All right.
And the diversity. I mean, it's our board, our staff. I mean, we're completely diverse in it. And I said, my affirmative action program, so make sure I have white lawyers on my staff. That's my affirmative action program.
Yeah.
I mean, 'cause I have to, I don't have to have white lawyers on my staff, but they bring something to LDF that's valuable. And so you look at our staff and you're going to see that mix. The issues. I will take a case, and we took one to the Supreme Court, involving the rights of a 62-year-old white woman.
The Kendall?
Age discrimination case. No, this is an age discrimination case. And the name will come to me. It was about 3 or 4 years ago. It'll come to me. But here she was, age discrimination case. And she thought she was about to be fired, and she took some documents home from the corporation, and she eventually was fired, So she said this violated the age discrimination. She and her lawyer, she's from Tennessee, brought the lawsuit, was dismissed from the district court. They said during the course of her deposition, it was learned that she had taken these documents home. And that's an automatically dismissible offense. So the court said that negates any age claim you may have had. So you're out of here.
Right.
Courts are always trying to clear off the dockets anyway. She went up to the Court of Appeals, she and her lawyer. The Court of Appeals threw her out by agreeing with the lower court, dismissed her. And they created a new rule there called the after-acquired evidence rule. See, before we go to law school, we speak English. Afterwards, it's the after-acquired evidence rule. So her lawyer contacted us.
Meaning that evidence acquired after the facts could impact
on the facts. In other words, during the court, after she had filed a lawsuit on basis of age discrimination, it was learned that she'd taken the documents home. That was that was after-acquired evidence. And so that new evidence, because the company said we would have dismissed her had we known she had taken the documents home, although we did not know it at the time.
Right.
So that erased her claim. It's an awful rule. So that rule was being cemented. So the question was, her lawyer then came to legal defense fund. Because one thing we know how to do is usually to get in the Supreme Court and then stay out of the Supreme Court. You have to know both sides of that. So so he came to us, and I looked at that case. I said, now why should LDF spend the $50,000? Because with all the briefing and all this, it's going to cost us money. This is a white female, and it's an age case. It's not a race case. It's not a case about any of the civil rights, but it's age and, 3 reasons I did it. I looked at it, I said, wait a minute. This is the Age Discrimination Act. Age and disability are acts closely, they're sister statutes to the civil rights statutes, to the voting and housing. All of the rights under those, because they come out of a provision of the 14th Amendment, Congress's authority. So I said, no, age is important, So I said, all right, there's sister statutes. What happened in the Age Discrimination Act, eventually, if we aren't careful, will seep into these other provisions of law, this after-acquired evidence rule, and negate our claims. The second reason I took it, I said, you look at this is age. And if I had an African-American male standing at the Supreme Court talking about rights, it may cast a different patina over the case. But if I have an age issue, the court may look at it with some greater understanding. Maybe. Maybe, I guess, a greater understanding. And then I said, also, it helps, I think, that the plaintiff in this case, below, you know, is female. And also it's white female. I said there are 2 justices on that court.
Who are white female?
Who are white female who will look at the facts of this case and will not only understand it, but will feel the injustice of what has happened to her. You know, and I said, and so through this we can make law that applies across the board. So I said, LDF's going to take this case. We took it. We brought her lawyer up there to them. We wrote the briefs. We first had to find the question to get the Supreme Court to take the case. And so we were able to do that. And then when the Supreme Court set the case down for argument, I told the lawyer that we would take the case on one condition. And that is if we felt that he could really make the oral argument and make an excellent argument, you know, that he could argue. Otherwise, if we did not think he could make that argument, then he would have to give that argument up and let one of our lawyers make it. And I said, if you agree to that, you know, you're going. So he agreed. We brought him up. We mooted him, took him to the moot court and the practice runs, and I mean, and then we second chaired him. And took him to the high court, and we had our lawyers who had worked with him sit next to him as he made the argument. He was masterful. He was good. We won that case, Julian. Reversed both courts below. Guess what the vote was?
What?
9-0.
All right.
9-0. So that, what I'm saying is, our issues, when we took on all of the height and weight requirements in employment law, we had so many restrictions in the law that had nothing to do with one's ability to do the job.
Right.
We said you had to be 6 feet tall to be a state trooper. Why? That's so when he's walking around and give you the ticket, you know, you can look up at him, I guess. I don't know what that had to do with your being able to be a qualified state trooper, that you had to be. Virginia had that law. It was across the country. And what did that law do? It disproportionately denied women, because who are not usually 6 feet tall.
Right.
Latinos are not usually 6 feet tall. And so you have a rule here that had nothing to do with your ability to do the job that eliminated whole groups of people. But we took it in under the Civil Rights Statute, the employment law, Title VII, challenged that in the Supreme Court. When we got that height and weight requirements, you know, to be a flight attendant, you can only be 110 pounds. That means most men are over 110 pounds. I mean, right then it was sex-based in the way the rules are crafted. So when we participated in taking those cases and we get rid of the height requirement, who do you help? Not only do you help Asians and Latinos and women, you help short white men. Short white men who before that could not get the position, now could apply and be considered. But nobody thinks about the civil rights laws in that way. They don't think about opening up opportunity.
They don't think about them in that way, and I imagine there are people who say don't go that way because you're not helping black people.
Yep.
Even though you may be.
But you are. When you open up, look, opening up the system always helps us.
Yeah.
Oh, all we want is opportunity, real opportunity to be able to compete and do things. We are too often shut out. If you apply the same criteria and the same benefits that you give others to us, we'd be golden. I'd take it anytime. But we don't get it. You know, they come down on affirmative action. This country has practiced affirmative action since its beginning. It's usually been economically based, alumni, athletes, and all that kind of stuff. We're saying, give us some of these same benefits.